No, they were panicking and they were thinking, oh shit, oh shit, oh shit, I have to hide a body. I have
Yes.
to hide 3 bodies.
Welcome back to the Daphne Blake channel. This is Hope, and today I am joined again by Rose. Welcome, Rose.
I hope. Thank you for having me.
Yes, I'm super excited to talk to you today. As most of our listeners, followers know, in the past couple of months, there have been some developments in the West Memphis 3 case. And
Yes. Some legal
before,
developments.
yes, which is why you are here. And before we jump into that, just kind of a little bit of business. I have seen these motions floating around in different places online. I'm going to tell everybody where to go find them officially. So online, go to caseinfo.arcourts for Arkansas courts.gov. And that will take you to a page where you can search by name. You're going to put in Echols, Echols, last name, first name Damien, Damien, and all of his cases are going to come up. If you scroll down a little ways, you're going to want to look for this case number. It's 18CR-93-516. And if you go down to that record and you scroll all the way to the bottom, it's going to show the most recent filings. And that's where you can get all of these instead of having to go look for the defense's original motion and then the state's response to the motion and then the defense's response to the state. These are all, you can get them all in one place. So that's what I would recommend. That's what I did. You can download them from there if you want to save them to go over them. But that's where I would go and look instead of trying to Google and find them all individually. Okay. So in January, the defense team for Damien filed a motion for new DNA testing. So I would like to just go through what they asked for. It's pretty brief, pretty to the point.
Do you know what they asked for? Because I just read it before getting online with you, and they didn't really ask for anything. They just said a bunch of things.
They did say a bunch of things. I believe that they intended to ask for permission to do M-VAC testing on some of the evidence. There is some confusion about a lot of things from that original motion. I think we can both agree that it was not very clear, very precise, or very well written. Would you
Fortunately,
agree?
yes, we can agree to that. Yeah.
Okay.
By the way, I am on Team Echols. I want this motion to be granted, but
Absolutely. Yes, me
I
too.
was disappointed with it.
Yes. Um, a big portion of the motion was 14 pages, I believe, was basically saying we're in the defense team has been involved with or prodded, I don't know, by a podcaster who has covered the case. And that podcaster said that maybe we should try this new method of DNA testing, which is M-VAC, on the evidence from the case. And so we think that's a good idea. So we're going to ask the court to let us do that. That's pretty much what the
But
motion
that's
said.
it is, but it isn't, because when I go through it, it's 13 pages. It starts with an intro section saying, hey, pursuant to certain code sections in the Arkansas statutes, it says, Damien Echols moves this court to permit new scientific testing of certain evidence in this case.
Mhm.
So, okay, we have a taste of, all right, we might be asking for scientific testing of, quote, certain evidence. We don't know what evidence yet, but let's keep reading, right? It explains that they want, the M-VAC wet vacuum testing, which is great. Okay, so then they move on to All right, background. Let's give you some background. And this is so far so good, right? You want to give a fact section that gives background, and then you want to make your arguments, and then you want to have what's called a prayer for relief. Right. So the background section can be summarized as follows, right? It briefly summarizes the case that Echols, Baldwin, and Miss Kelly, as teenagers, were convicted of a horrific crime involving the murders of 3 boys. Very, very succinctly, it summarizes, hey, eventually in November 2010, the Arkansas Supreme Court ordered the trial court to hold a hearing. It really skips over most of the procedural history in this case and sums it up in that one sentence. There was a ruling from the Arkansas Supreme Court ordering the trial court to hold a hearing.
Right.
Okay. So if you want to know anything more about that, you have to go back and look at the record yourself,
Yes.
which I think, frankly, is mistake number one. If it were me, I would have laid out the procedural history in a little bit more detail in case. I think they're making an assumption that the judge knows just as much about the case as somebody that follows all the podcasts and all the documentaries and is really that's not necessarily true. And
Right.
you shouldn't necessarily make that assumption. Even if they have heard of the case, that doesn't mean that they know as much about it as you do. You're the attorney. Of course, you know a lot about it. You need to explain, okay, no, they were tried, they were convicted, they appealed, then there was post-conviction motions, this is what was argued, this is what was ruled on, this is what, go through that procedure in a little bit more detail. Then it explains the offered plea situation and talks about almost kind of like a gentleman's agreement almost. I can't really tell from the motion itself.
Right, with Scott Ellington.
What was discussed, which is interesting because the plea agreement is mentioned, but they're not alleging here that the plea agreement says that the state would agree to DNA testing, only that hey, we've made this agree, we talked about they would agree to it. But they're not, I don't think they're actually alleging that, hey, we there's something that they signed saying that they wouldn't oppose it or anything like that. They're just kind of giving some context, right?
So from what I understand from the offered plea, in the language in there, the state agreed to maintain the evidence from the case, which isn't, from what I understand, also is an Arkansas statute and is pretty common in every state, that they keep evidence sometimes for forever, sometimes for so many years, if it is a violent crime or if it's a crime that involves, a sentence that could be life in prison or the death penalty, that sort of thing. And so they, in the agreement, they did agree to keep the evidence in case it needed to be tested, re-examined, whatever, but didn't say they would. And so there's a difference there. And so the what they're alleging is that Scott Ellington, and he did actually, I've seen the clips, he said it on TV actually, that he would entertain, theories, thoughts, whatever, that anybody brought him, that might show that the 3 defendants were innocent, and that might involve DNA testing, and that he would be willing to do that. And he did say that on TV, but that's just him saying it on TV. He didn't sign anything.
Sure. Okay.
That said he would do that.
Outside of that background, the motion goes on to explain the podcast that you mentioned and the documentary that you mentioned, where this M-VAC wet vacuum testing first was mentioned. And then from there, it appears to go through a whole much more detailed timeline of events where the motion explains all of the conversations back and forth between the defense attorneys and the state on whether or not they're going to be able to negotiate an agreement for testing.
Right.
And that's
which included
of the background section.
Yes. And not to be picky, but a lot of that was petty, like finger pointing and you said this and you did this and you lied about this and you tried to keep us from doing this, and you know,
Right.
it didn't read well. I didn't think legally. I mean, I'm not a lawyer, but I've read a lot of motions. Um it kind of went off the rails, in my opinion, in
I
that
think I
section.
agree. I agree. It also, um, and this is maybe it's petty of me, but there are certain things like I just don't think it was edited well. Like, for example, there are
Oh,
places
typos.
in the motion, there's typos, there are places
Hmm.
in the motion where the font isn't the right color. There are places where there's very clearly a spot in here where they like made little notes to themselves that
Hmm.
they really intended to delete, I believe, before filing.
Called the
Although
district
I
attorney by
see,
the wrong name.
yeah, although I, yeah, I see that they did file an updated one that I think they
Yes,
corrected some of
there
the
was a
typos.
correction. Yes.
So, but still, I mean, it's not a good look for an attorney or a team, rather. I know it's more than one attorney. Like you've had a lot of time to draft this motion.
Mhm.
And in all of this time that you've spent going back and forth trying to convince the district attorney to just agree to the motion, you could have been writing the motion,
Right.
right? So the problem appears to be when Cressman takes over and is like, look, basically he tells them he's not going to agree to the testing, but he says it kind of in like a roundabout, like overly polite way. And it's just like, look, I'm not going, like, basically he says you're going to have to file a motion. That is prosecutor speak for I'm not going to agree to this.
Yeah, he's
It's going to
washing
have
his hands of it.
yeah, he's like, you sign, you file your motion, and we'll see what the court says. Like, that is prosecutor speak for this conversation is over. Go do what you have to do,
Hmm.
you know? Um, and even still, like, again, I know that this is getting into the weeds a little, but the defense attorney is like, hey, I've attached an agreed order. Can you please sign it? And I thought it was interesting. I don't know what the agreed order said, but I thought it was interesting in rereading this that the response on January 7th that Cressman sent, which is detailed in the motion, is just like, hey, I've reviewed the proposed order. It says there is statutory law for addressing new scientific evidence and governing physical evidence, but the proposed order doesn't reference them, nor is there an explanation of how the proposed order
Hmm.
comports with the law. It doesn't cite any legal authority. I can't imagine the circuit court entering this order. I will renew my original suggestion, which I emailed to you more than 9 months ago. You need to file a petition. So in other words, he's just like, he's saying, I told you 9 months ago, I'm not going to agree to this.
Right.
I'm telling you again, I'm not going to agree to this. Also, your motion has or your proposed order has problems. Um, and that is when the background section of this motion ends. So we're 8 pages in, and the only facts that have really been laid out for the court's consideration is that they had a massive argument over whether or not to agree to DNA testing, and then eventually they realized that they were not going to agree to it.
It's whining.
It really is. It
It's
doesn't
whining.
set out. You're so already, you know, I haven't seen any facts here that
Hmm.
would be relevant to what I'm being asked to decide, which so far we're 8 pages in. And the only thing I know that we're being asked to decide is whether or not they're entitled to, quote, scientific evidence of certain pieces of, or scientific testing of, quote, certain pieces of evidence. Right? We
Hmm.
don't even know what pieces of evidence they want tested yet.
Well, so that was actually the thing that jumped out to a lot of people, including myself. In Let's see if I can scroll up through here and find it, because I took notes on each of the motions. So originally they had, when the first request was made of Scott Ellington when he was still in office to do the testing by this podcaster, they wanted to test the boys' shoes, socks, Michael Moore's hat, the boys' shirts, pants, underwear, the ligatures, and then the sticks that were used to push the clothing into the mud.
Mhm.
And then in this motion for DNA testing, they briefly talk about that they just want to test the ligatures because that's arguably the most important piece of evidence in the crime that the killer or killers would have handled. And so a lot of, in reading different reactions online, that's the thing that stood out to a lot of people who follow this case, including myself, was why. I understand the reason for wanting to test the ligatures, obviously. And we'll get to more of that, as you know, when we get into another motion here in a few minutes. But it's interesting that they dropped wanting to test all of the other pieces of evidence.
Interestingly, they seemingly dropped it as they were writing the motion, because the
Mhm.
motion starts out listing all of those things. And then as you continue to read, it's like, and here is why we really want to test these ligatures. It's
Yes.
like really like between page like 3 and page 8 or whatever, it's you've morphed what you're asking for, which is why what you should do is end your motion with a prayer for relief, which asks specifically, okay, court, I am asking for testing of item number 1, item number 2, item number 3, item number 4, and list the things so that we are very clear on what you are asking the court to order.
Okay. So I have a question. If I don't know how many like bites at the apple they get for requesting testing of DNA evidence. I have no idea how that works. How many? So let's say this is their one shot. Wouldn't you ask to test all the pieces of evidence that you think might be relevant to trying to exonerate your client rather than asking to test one type of evidence?
You should.
Okay.
Yes, you should. And even if it's not your one shot, I don't see, and maybe there's somebody with different experience than me who might have another opinion, but I can't think of a strategy of like this is why it's in my client's best interest to only ask for testing of part of it now. Like, why wouldn't you want to just go ahead and test all of it now, even if you do get another shot later? Like, well, why not now?
Well, that's my question. Like, is it almost appears like they think they're over asking if they ask for more than whatever they deem as the most important piece of evidence. And I thought that was kind of strange. I,
Um, and I don't know if that is the reason or what the reason is. I can certainly see, I've seen lawyers do that where they're like, oh, if I ask for too much, they're going to say no. Let them say no. Let them say no and write down in their written opinion why they're saying no. Make them do that.
right. But the thing here is that it's not about, the question isn't, can we test the ligatures or can we test the shoes or can we test whatever piece of evidence? The question isn't about what pieces of evidence or piece of evidence we're going to test. It's about the method of testing. So if you can get the method of testing approved, if you can get the court to agree to let them do this method of testing, then I don't think it would matter whether you're testing one item or 12.
I guess, yeah. So, and that's where there's not a lot of clarity on what exactly they're needing the court order for and what, even with the dispute that is outlined for us in the motion, the dispute appears to be that the state does not think that the defense is entitled to testing, like what you said, that they're not entitled to it at all.
Okay.
And so if that's the case, then we're litigating whether or not we're entitled to testing. And if the judge agrees that we are, then great, here's the list of things that we would like tested, please. I could also see a scenario where, and in the state's response, maybe they hinted that they might object to specific items, but the state could also say, look, it's not the DNA testing in general that we disagree with. It's you asked for testing of X, Y, and Z, and I don't think it's appropriate to test all of those, but we've got A, B, and C over here we might agree to, or maybe X and Z, but not Y. Here's why we object to Y. And so now maybe you're litigating specific items of evidence, which, by the way, that's the Michael Morton case. In the
Right.
Michael Morton case, they weren't arguing over whether or not the new DNA testing method was a good one, or whether it was scientifically valid, or whether or not otherwise they would be opposed to it. What they were arguing about was whether or not that bandana had relevance.
Right.
Right? It was, this bandana is too far away from the crime scene. The defense can't meet their burden to show.
And it
that
was what,
any
like 60 feet behind the house or something?
Oh God, yeah. We don't even need to talk about Michael Morton. Yeah,
Right.
it's a whole rabbit hole. But that, like, just as an example, though, it wasn't about whether or not the DNA testing should or shouldn't be done in general. It was like, no, we're opposing to DNA testing this item. So it's hard to tell from this motion what the disagreement is. Is it that they didn't want to agree to DNA testing at all? Is it that, I mean, is the reason why they changed what they're asking for because they thought that the state would agree to that and not the others? Like, it's difficult to tell. But at the end of the day, the state doesn't have to agree to something. If like, you can ask in your petition, this is what we want. This is everything we want. And the state can then come back, as they did, and say, nope, this is why we're not going to agree to that. This is why we're opposing it. And then the judge gets to make a decision. So quite frankly, I thought it was a waste of time to go into the whole chronicling the timeline of your negotiation and your breakdown of that. It's not relevant. What we needed is, I needed to see, and we're going to talk about the argument section next, I would imagine, but
Yes.
I want to know, like, if I'm going to rule on this motion and I'm the judge, and your job as the attorney to tell me what you want, what law you're relying on, and the facts that you intend to show at this hearing to back that up. I can't get that from this motion because you haven't shown me anything. Like, you haven't even cited the law that says what you have to prove
Right.
to get DNA testing.
Yes.
Which I'm sorry.
No, you're fine. It came off as petty.
So petty.
Yeah.
The first 8 pages is just whining.
Yes. So we are going to get into the state's response next, but one last comment on this original motion asking for DNA testing. The other thing is, in talking about why they've gone from wanting all these things tested to just the ligatures, I'm also wondering if that has to do with the cost of the testing.
I mean, possibly. But still, what I would have wanted is a motion to specifically say what it is. And I think that it's probably safe to infer from the background section of this motion what they're asking for, but that's not where that goes, right? And maybe this is just me being, like, overly formulaic about stuff, but like, the argument section, which starts on page 8 and goes through page 11, so it's 3 pages. The only law it cites is the DNA retention statute, which is really not what's at issue here, because the DNA evidence was retained despite possible I mean, I know there was issues with maybe it was lost or destroyed, but that turned out to not be a thing.
Right.
And so the DNA has been preserved in accordance with the statute. So I thought that was odd. Like, is there not a statute in Arkansas that says, hey, here's what you have to prove in order to be entitled to DNA testing after the fact? And if so, please cite that, right? And then say, hey, here's why we meet those requirements.
Yes. I think, like I said, I think the original motion read as petty, and I got done reading it and I literally thought, you need to let this go.
Yeah.
I understand it was a big thing. I was hooked on it too. Like, every time there was some news, article or, a news interview in the local news in Memphis, West Memphis, I was glued to it because I thought, did they really lose, destroy, whatever, all of this evidence? Because that's huge. If that had been true, that would have been a big deal. And so I was into it too. But, then we find out through all these FOIA requests, there was no fire, there was no water damage, there was no nothing. And then they go and they inventory all of the evidence and it's there. Okay, great. Now let's move on. But they can't seem to move on.
Uh, if you lied about it, and if you have some kind of like prosecutorial misconduct claim based on those lies, then
Mhm.
by all means, make those arguments, put it in your motion. If that's part of your argument is that, hey, here are all of the reasons why we need DNA testing. And oh, by the way, the state has been acting in bad faith, right? Then
Yep.
then fine. But that didn't seem to be the argument that was being made. It was
No.
just, here's here's what's going on. They won't agree to this. It was
They're not playing fair. Make them play fair.
right. Right.
Yeah.
Right. Punish them for not agreeing to something that they should agree to. I mean, at the
Yeah.
end of the day, reading the conclusion section, the gist of their argument is this is the right thing to do.
Mhm.
And by all means, it is the right thing to do. But
Absolutely.
this is the right thing to do is not a legal argument.
Correct. Okay, let's go to the state's response,
Okay. All right.
which was filed February the 8th.
Mm-hmm.
So let's just kind of go through it we'll start at the beginning. So the state is saying that there are several reasons that Damien Echols does not meet statutory laws for DNA testing. So
Mhm.
their first one was that the motion was filed in the wrong county, which made me chuckle.
Embarrassing.
Embarrassing. So I think kind of maybe what we'll do is since they have these points that the state is making, the defense did in their reply to the state's response, they did address some of those. So I think we'll go through them
Yes.
together and
Okay.
see what see what the defense's response is to the state, if that's okay with you.
Yeah, that's fine.
Okay. So the first thing that the state mentions in their response for Echols not meeting statutory laws for testing is that the motion the defense filed was filed in the wrong court, in the wrong county. They filed it in Crittenden County, and the state is saying that it should have been filed in Craighead County. And after we did some digging, it appears they might be right. Correct?
Yes. So the statute in question is Arkansas Code, and it's section 16-112-205. Right. And so the Arkansas Code, the way it's laid out, we're in chapter 112, which is the habeas corpus chapter.
Mm-hmm.
And that's important because of the language of the statute. If you read this section is subtitled hearing. So it's giving you the rules for having a hearing under this subchapter, right? Meaning these are the rules for having these kinds of habeas corpus and DNA hearings. And
Okay.
under subsection B, it says hearing on a petition filed pursuant to this subchapter shall be open and shall be held in the court in which the conviction was entered. So I guess the question I need to look, and I'm going to kind of look at the code as a whole, but it appears that what what Echols is asking for is a hearing under chapter 112.
Okay.
Right. And specifically under subchapter 2, which is new scientific evidence. This seems to be where we fall under. And if that's the case, 16-112-205B says that it has to be filed in the court in which the conviction was entered. And I don't see any getting around that, because when we went and looked at the offered plea, that was entered in Craighead County. So I don't know how we get around that.
Right. Yeah, I don't know either. There doesn't seem to be any kind of plea or conviction listed in Crittenden County for any of the defendants.
Yeah. unless there's something that we're missing here. But I don't I don't see how we could be.
All right, well, I guess we'll have to let the defense team figure that one out because it appears the state might be right on that point.
So the defense's response is that actually the conviction is out of Crittenden County. That's their response. The state,
Right.
sorry, I keep confusing the parties. The defense's response is not you've misinterpreted the statute.
Correct.
The defense's response is actually you're wrong. Whenever there was a new trial entered, they actually entered their offered plea in Crittenden County. But if you look at the offered plea, that's not the case. The
Right.
heading is pretty clear that it was entered into in Craighead County.
Right. In fact,
I mean,
none of the
maybe-
defendants had entered their plea in Crittenden County. Miss Kelly's was entered in Clay County, and Echols and Baldwin's was entered in Craighead County.
I mean, I guess, is it possible that they were physically sitting in Crittenden County and that's why there's confusion? Because I know that there was a visiting judge to handle the proceedings. But I mean, what matters is that the offered pleas heading, the style of the case is Craighead. And so
Yes.
that's where it was filed. That's what matters.
It's very clear, and it's stamped as such on the document.
Right. That's what matters. And so the only thing I can think of is that maybe if they were physically in Crittenden County, because I know that there was news people there and maybe they needed a place with bigger space. And sometimes I've seen that happen where it's not a change of venue, but you're physically in a different location due to space constraints or whatever. But even in those cases, it's like, okay, no, like if I'm in one county, in County A, and we, for whatever reason, need to move to a better space, it's not a change of venue just because you're physically located in another space. Because I have seen that done before. I mean, the judge will go over, the jury will go over. It's a, County A jury, even if you're physically located in County B, unless you have a motion to transfer venue, which there was in this case, transferring it to Craighead.
Right.
I mean, that's the only thing I can think of as to maybe why there's confusion, but the documents say Craighead County. So I don't know how you get around that.
Well, I have seen video footage from, the day that they took their offered pleas. And I don't honestly remember what courthouse they were at, but having been to Crittenden County, that is not a place for a photo op or that has lots of space or that kind of thing. So if they were in Crittenden, it was only because that's where they were originally charged, where they were arrested, where they lived.
That doesn't make any sense though,
No.
because the case had been transferred to Craighead.
Right.
So I don't know. That just seems like a pretty fatal error there.
Yeah. Okay, so the second one is that because the defendant, Damien Echols, is no longer in custody, he cannot file a habeas motion. Counselor, could you explain this one to me?
This one was a little bit more incredulous to me on the part of the state.
Yeah.
And again, I think the defense does a really good job of responding
I thought so
to this, because that is, I'm sorry, ridiculous. You absolutely can file a post-conviction habeas motion if you are convicted of a crime, regardless of whether that sentence has been completed or not. But also, I'm now confused because now I'm not sure what the defense is filing, because I thought they were filing a motion for DNA testing. A habeas motion generally asks for some kind of relief from the conviction. And go ahead.
Well, I was confused about that too, because they kept referring to Act 17 to it as an Act 1780 petition. So in Arkansas, an Act 1780 petition is a habeas petition. Because I had to look it up because I was like, I don't know what this is. And so apparently it is a habeas petition. And so in the defense's reply to the state, they quoted the Supreme Court and said that there are many disabilities or burdens which may flow from a defendant's conviction that give him a substantial stake in the judgment of conviction, which services the satisfaction of the sentence imposed on him. So yeah, so no, what that basically means is like, look, there is more
to a criminal conviction, particularly one as serious as homicide, murder,
Mhm.
that restricts your freedom, right?
Right.
Because what a habeas petition is, it is a well, a habeas writ is an order demanding that the state show cause why somebody's freedom is being restricted, which generally, yes, traditionally means why somebody is in custody.
Mhm.
If you think of like traditionally, the way the writ was used, it was to free people from being in custody on like no charges, right?
Mhm.
And honestly, I'm kind of rusty on my history, but it is, even though now it's considered like it's a post-conviction tool that's used, traditionally it was more of a pretrial thing. Like, hey, you're being detained. You haven't been, like you haven't been told why you're being detained. You're stuck here to rot without a trial.
Mhm.
You have constitutional rights. Those are being ignored. You can't just come in, swoop somebody up, and throw them in jail just because you are the state. So that the great writ, as the habeas writ is called, is used as a tool to protect somebody's constitutional rights, to ensure that they have due process and that you're not just arbitrarily throwing people in jail.
Right.
It has
Well,
evolved into a post-conviction thing.
so
Um,
I think we would agree, though, that even though Damien, as well as his co-defendants, um, are no longer in prison,
right.
they a lot of people still believe they committed the crime because they haven't been exonerated. Their names have not been cleared. They have
Right, they still
trouble.
carry the convictions. Yes.
Correct. They have trouble getting jobs. Um, all the things that come with a felony conviction, not to mention the fact that it's the murder of 3 8-year-old boys.
You're absolutely right about all of that. And because of things like that, when the habeas writ started to be more traditionally associated with like post-conviction stuff,
Mhm.
the Supreme Court did say, like, hey, um, it's a conviction can restrict your freedom in more ways than just physically restricting your
Right.
movement, right? There's more to it than that. And so anyone that has a conviction on their record can file a habeas writ. Now, there are some other, we can talk about the timeliness was the next one.
Yes.
So
The
there might be issues on how long after and procedural bars and things like that, which are definitely can be issues. But are you entitled to a habeas, like, are you no longer entitled to a habeas writ simply because your sentence has been served?
No.
That's not true.
Yeah.
Like that is just generally not true.
Okay. Yeah. So the next thing is that they can't file a habeas petition more than 36 months after conviction. They're saying that that is untimely. The
Mhm.
defense the defense's response to the state is that basically they're filing because there's this advancement in DNA testing, namely M-VAC, and that it wasn't available within 36 months after conviction, therefore it does the time limit doesn't matter.
And I think that they're right, but I think that this is where I would have devoted more space in not just the response or the reply rather to the response, but in the initial petition as well. Because
Mhm.
even though it seems a really easy issue to resolve in the defense's favor, you still should devote time to explaining, like, hey, there's a potential procedural hurdle that we have to get over first before we can entertain the merits of our motion. Here is why we have overcome that hurdle, and point by point go through that. The state in its response even lays it out and it says, hey, this hasn't been addressed. You're making so we don't know how you're going to try to get over that procedural hurdle, but we're assuming that here are the reasons. But in order to actually overcome that hurdle, the court has to find these things, and you haven't actually asserted this or offered anything in support of it. And then the defense just comes back and in one paragraph says, yeah, absolutely. Like, because this is new scientific technology, we should be entitled to a petition now. And I have no doubt that they are right and that that is what the code allows. But I wish that they would have given more space in their motion to, this is why we can overcome this procedural hurdle.
Yeah, I agree. And so then that is the next thing, is that the state says, well, we assume that you're going to make these arguments. So if you're going to make these arguments, what you have to show the court is that, one, M-VAC testing is generally accepted scientifically, and that, two, um, that M-VAC would not violate the requirement that physical evidence be preserved, which I think is kind of funny, personally.
I think this is an interesting argument that the state makes
Right.
here.
And so the defense comes back and cites, the FBI has done these, this testing with M-VAC, and they've certified that it's, scientifically valid, and they can't find any cases where M-VAC has been used, where it has been thrown out of court, that kind of thing. And so they're saying, based on the cases that they've looked at, it has been accepted scientifically. Obviously, the state is saying, well, not in Arkansas. We only found 2 cases
Yeah.
where it's been used in Arkansas. And,
And again, I think the state is being disingenuous. And this is a problem I have that frustrates me a lot when it comes to scientific evidence
Mhm.
in any kind of criminal case, right? The state wants to rely on something when it's convenient for them, but not when it's not, right? Like
Yes.
it drives me absolutely nuts. A good example, let's talk about like science that used to be used, but we all know is bullshit now, right? So think like bite mark evidence.
Yes.
Ask any odontologist, ask any person that actually does work in this field these days. Most people will tell you, if they know anything about this, it's not really reliable or as reliable as we used to think. You can eliminate somebody, you really can't, like all that stuff that we used to think we could do with it as far as like matching, and you really can't use that language anymore. But still, in 2022, prosecutors all over the country will go to case law and say, well, judge, according to this case law from the 1980s, bite mark evidence is scientifically valid. And unfortunately, judges really like to look at case law rather than what scientists are saying today about how valid a specific, scientific testing or whatever method is. And it's really frustrating to see the state rely on case law for something like this. It's like, okay, like you know that this is an accepted scientific method. You know that there is no reason to doubt it. Now, should the defense, it's their motion and their burden to prove it, should they be required to bring somebody in to testify and prove up that scientific evidence and give you an opportunity to cross-examine? Sure. But they can do that, and I think that it's disingenuous to say, well, it hasn't been used in Arkansas yet. Like, okay, I guess, but that's a really weak argument.
So you can't see me, but I'm over here laughing because I don't know if you're aware. Your example was was quite funny to me, because there's a huge piece of evidence in this case that involves a bite mark, an alleged bite mark, a human bite mark,
Mm-hmm.
and an
I think I've
odontologist
heard of this.
who who swears up and down that they can match it to someone's teeth. I'm just saying, a lot of followers of this case are very well acquainted with this piece of
Oh, I'm
evidence.
sorry.
And
I didn't mean any offense.
no, I just it was funny to
But
me.
just be
So
cautious, because bite mark evidence has no
it's
place
not
in
reliable.
courtrooms.
Yes.
Yeah.
Okay. So then the second prong of this was that if the M-VAC, using M-VAC would violate the requirement that physical evidence be preserved. And this, I literally laughed out loud when I read that, because I had the same like ideas and response in my head that the defense came back with, which was, So if you're required to preserve physical evidence, there would never be any DNA testing. Like
Right.
if you
Yeah.
had to preserve all evidence, there would never, the traditional method of wet swabbing, they would, let's say it's a stain on a pair of pants. You would cut out a part of that stain if possible, unless it's minuscule. You would cut out a part of that stain and wet swab it and send the swab off. So obviously you've cut out part of this piece of evidence. It's forever altered. It's now gone. You've cut it away from the existing piece of evidence, but there's more remaining on this pair of pants.
Hmm.
This, is what we're talking about. Um, but in a lot of cases, the evidence is teeny tiny, and you only get one shot. So if you want to do testing and you do DNA testing, you've taken the only sample that there is. So
Right.
this argument that that doing M-VAC testing would violate the requirement that physical evidence be preserved just kind of cracked me up, because if that's your
Yeah.
argument, then no DNA testing would ever be done, ever.
Right. Now, if the argument is instead because this type of DNA testing would consume the entire piece of evidence, because of that, we would like to be satisfied that, X and X, Y, and Z requirements are met.
Mhm.
Okay, I could take that a little bit more seriously, but it seems that the state is opposing DNA testing in its entirety
Yes.
because of the fact that the DNA testing would consume the evidence.
Mhm.
And I'm not, it's interesting too, because the statute, the DNA preservation statute and similar statutes across the country, they're written to protect the accused, right? They're
Yes.
they're written for the benefit of those wishing to do the DNA testing later. They're not written for the benefit of the state. And I always find it kind of interesting in cases like this when you see the state trying to rely on laws that are designed to protect the defendant and trying to use them as like, hey, no, we're just trying to protect you, right? Like we
Mhm.
don't, and they wouldn't mention the other two defendants, which again, like we can talk about that a little bit later. Like I wish all three of them had signed on to the motion. I'm sure there are
Well,
reasons
and
why they didn't.
that's their next
Yeah.
point. So we can go ahead and talk about
Yeah.
it, because that they say that by doing the DNA testing, should it ruin or forever alter the item that they're testing, that it would prejudice his co-defendants who did not join in this motion.
I think that while again, I can see where you're coming from. Like I can see where the state's coming from
Mhm.
with that argument.
Of course.
But I do not for 1 second believe that the state is concerned about Jason Baldwin and Jesse Miskelly. That is
No,
not what they are concerned about.
and
They
not
don't give a
only
shit.
no, and not only that, but if you know the case at all, if you're familiar with the case, then you know that Jason and Jesse would not oppose DNA testing. I don't know
I
why
hear you.
are not join they did not join in on this motion. I'm not sure if that was just like a legal thing and their attorneys didn't get involved, or I don't know why they're not, and it was just Damien. But I don't necessarily think, um I mean, you can't just make that assumption, but from what I know
right,
about the case, they wouldn't oppose that. And so I think the state does have a point, that
right.
there are two other co-defendants convicted of the same crime, and so they also should get a shot at whatever Damien's getting a shot at.
So I know that a response to that is one response would be to call up the attorneys for Baldwin and Miskelly and say, hey, can you join in this motion and
Yes.
cut that argument right out? That would be
Yes.
one response. But even if you don't want to do that, or you can't do that, or you don't have a good relationship, or I think one of the clients doesn't want to be involved, like, well, you can't, if you don't have client approval, you can't start filing motions on his behalf. So
Right.
if that becomes an obstacle, I think that there's still this argument to be made that, hey, this is not going to violate anybody's due process rights because the DNA test results could benefit all three. And here is
Mhm.
why. Here's why. Here's the claim being made. Unfortunately, we only represent Damien, and so we can only speak for Damien. But all three were wrapped up in this together. The evidence against these two were really that they were friends with Damien. And so if it exonerates Damien, it exonerates them as well. Like,
Correct.
I would have wanted them to delve deeper into, hey, there are actual real reasons why it would benefit the unnamed co-defendants that have not signed on to this motion, and the state can't really show there's no good reason the state has given why this DNA testing would harm them. Now, they did mention, like, oh, there's other ligatures. I actually think that there's and I don't know if you can assume that, like, all ligatures are created equal, and
No,
I did
no,
think
you
that it was
cannot.
I did think that that was a interesting argument to come back with on the part of the defense, where they were like, hey, like, there are other ligatures that if they want to test them, they can get them tested as well. But
So let me put a point on that, because that is actually fascinating to me, having studied the case for a while. So the the defense's reply says basically that there are six ligatures for potential testing. Um, there is nothing in the evidence that suggests that any of the ligatures were handled any differently in respect to any victim. So each ligature presents an equal potential evidentiary value for M-VAC processing. I'm going to have to completely 100% disagree with that. Um, and
yeah,
that may
yeah.
just very briefly, from the work that this team has done, and a lot of people who are familiar with this case know that there were different knots tied in those ligatures. Some people say it's no big deal. They're kind of close. They're kind of similar. They could have easily been tied by the same person. There are other people who say it's evidence that there was more than one person who tied the boys. Um, so I don't think, without knowing that piece of information, you can say that all of the ligatures are equal in
Mhm.
the evidence that they could show. Because if there's one killer, okay, but you don't know that there's only one killer. No one knows that
Mhm.
except for the killer or killers, correct?
Right,
So
right.
if there is more than one killer, then it absolutely matters which ligature or ligatures are tested.
Hmm. Yeah,
Okay,
no, I
I'll get off
agree.
my
I
soapbox.
agree. No, I think that those are all very good points. I think that that was a very it was an assumption being made by the defense. I don't know if it was just because they were trying to come up with a response, that this
Mhm.
is the response that they came up with, or if they just hadn't really sat down and thought about it, or if I'd like to know if they have their own team of experts that have taken a look at the available evidence and given them an opinion on what should and shouldn't be tested, like if this is the
Mhm.
advice that they're getting from somebody, or if this is just a lawyer trying to respond to a brief.
I guess so.
Um,
If all three of the defendants agreed and wanted the testing done, then I would say you talk to a group, a group of experts who have analyzed the ligatures and the knots. And if you only get one shot, if the state says you can test one ligature, you confer with these people to decide which one is going to yield the best results based on their theory of what happened. If you only get one bite at the apple.
why? I guess I just don't understand. If I'm the court and I'm having to make a decision on this, I don't see any reason why I would let you test only one. It's either you have the legal right and you've established your statutory right to DNA testing on all of them, or none of them. I don't see a situation in which the court says you've met your burden on one, but not the others.
Well, I'm assuming it's because the co-defendant's not joining in the motion. So if all six ligatures are equal, as the defense claims, which is not true, then if Damien is allowed to test two, and Jason is allowed to test two, and Jesse is allowed to test two, they each have an equal opportunity to test the ligatures. But that's all the ligatures being equal, and that's not the
How about
case.
this? How about this though? Um,
If Damon gets to test all 6, and Jesse and Jason aren't joined on this motion, and they don't want testing, or who, for whatever reason, does that prejudice them, is my question. If let's say the court lets them test all 6 ligatures, and then later Jesse or Jason wants to do some sort of testing with the ligatures, but they can't now because they've been tested with M-VAC and all of the DNA has been pulled out of there, then what?
so I think that to answer that question, we have to really look at the DNA retention statute,
Okay.
because the defense, I say the defense team in their petition, which really they're the movant in this case. So now they have the burden to prove something, right? But the defense team, they start with the DNA retention statute, and they go into this whole legislative history of the purpose behind the statute to protect rights of those who have been convicted so that maybe they can prove their innocence later. What's interesting is that the state's argument is, by consuming the rest of this evidence, what you are doing is you are damaging the due process rights of the other 2 co-defendants. I think that we're making an assumption, and maybe this is just a product of Arkansas law that because I'm not a practitioner there, I'm not as familiar with, but I feel like we're making an assumption that there are due process rights tied up in that statute. There is a difference between constitutional due process rights and statutory rights. And whose right is it, right? Like, if it's a statute that says the state has a duty to preserve evidence, I'm not entirely sure that a court could or would read that statute and read into it due process rights. Like, do you have a due process right? And whether, like, how you know that, what would happen? Say the state had destroyed that evidence. Say there was a fire.
Okay.
Say that evidence had actually been lost. Say that we were going down that road. What would Damien's remedy be? Because if that's a constitutional due process violation, that evidence was destroyed, then he might have a better remedy than if simply the state didn't follow the statute, right? That's a statutory right. Is it even really a right? Or is it just a duty that the state has? And I know that sounds like I'm being like real,
Semantics.
it sounds like it's semantics, but it could make a big difference, because if something is a due process right, that's a constitutional right.
Yeah.
And if something is simply just a duty in the statute or a statutory right, that's very, very different. And so for the state to say, hey, this violates somebody's due process rights, that is a big deal. And so I think that first, if the court is really going to answer that question, and I don't know if they will, try to answer that question, but if they wanted to address that argument and try to answer that question, first they're going to have to determine, hey, I keep saying hey. First they're going to have to determine, is a due process right actually created by that statute for to be violated? And I think that if yes, then maybe. Then the answer to that question is maybe. If Jason Baldwin has a due process right to have that evidence retained, then you would have to answer the question, like, well, what about it? What about in a situation where there's co-defendants? What do you do in that situation where the rights of one person to test the evidence violates another's right to retain the evidence? How do you resolve that conflict? But I'm not entirely sure that it creates a due process right.
I don't know the answer to that either. I feel fairly confident that if that was an issue, that they could get Jason and Jesse to join the motion, and that would no longer be an issue.
Probably, yeah. But surely there's some kind of case law out there. This is certainly not the only case that had co-defendants, right?
Right. Mm-hmm.
So surely there's some kind of case law or precedent out there on how Arkansas has dealt with a case like this when you have multiple defendants.
Yeah, I don't know what that is. Maybe we'll have to look that up, or we'll see what they what the defense comes up with.
Yeah,
Because as I
for sure.
understand it, that this is it for responses to the motion, and that next the defense will ask to have um I assume oral arguments or written arguments for the judge in defense of their motion. Is that correct? And then a judge would
There should be some kind
decide.
of hearing. There
Okay.
should be some kind of hearing. This was filed in, hang on, I'm scrolling up to see the style of the case. It was filed in the circuit court,
Yes.
which is the trial court, yes.
Mhm.
So they can put on evidence too if they want. And in fact, probably the state will, if they don't try to put on evidence, they'll probably try to use that against the defense. I would highly recommend, or I would hope that the defense is going to try to create a record and to call witnesses and put on evidence so that they can explain to the judge and lay a foundation for, okay, here's why we've established that we have the right to this. It shouldn't be too hard to do. Bring in somebody from the lab, ask them questions about the scientific testing. How long have you been using it? Have there been peer-reviewed studies? That shouldn't be too hard to prove up, but I think that the defense would probably want to do that, bring somebody in, and have it open for cross-examination so that you can show the judge what it is you wanting to do, as well as point to parts of the record. But yeah, they can also rely on the trial transcripts, facts that were established at trial, which I'm sure the state is going to want to try to do. So yeah, they can have a hearing, a full hearing. It doesn't have to just be oral argument.
Gotcha. Okay. So back to the state's response. So next, they said that the defendant must show that testing will establish actual innocence.
Well, so the state cites a code provision, and in footnote 23, the code that they cite is the person making a motion under this section identifies a theory of defense that would establish the actual innocence of the person in relation to the offense being challenged.
Mm-hmm.
So what the state is saying is you are not entitled to DNA testing unless you can show that the results that you want, even if you get the results you think you're going to get, that would actually help your case. And this also kind of can be compared to the Michael Morton case, because a big piece, a big argument was, again, the bandana is too far away from the crime scene.
Mm-hmm.
So in other words, the state was arguing in that case, even if you test the DNA on that bandana and Michael Morton's DNA is not on it, who cares? That doesn't establish that you're innocent of this crime. That had always been the state's argument. And so this, I think, is a similar argument. Like, you haven't established defense that if you run a DNA test and the 3 convicteds' DNA is not on there, then that would establish their innocence. Now, I disagree with that argument, but that's what they're saying.
Well, and they've done this before. So there was previous DNA testing prior to the Alford plea, and that DNA testing showed that none of the DNA from the evidence tested belonged to any of the 3 defendants. There were 2 people who were identified from that DNA testing, and they were explained away as possible perpetrators. But they said, just because their DNA doesn't show up doesn't mean they didn't do it. And
Right.
so that's the question I've had all along is we've already done this, right? This case has already been through that once. So why? Yes, it's a different technology. It's a new technology. It's a better technology from all accounts. But let's say they test all 6 ligatures and none of the 3 defendants' DNA is on any of those ligatures. How is that any different than the results they got 20 years ago?
So my understanding of the results they got 20 years ago was that it was 2 hairs. One of them found in a knot
Yes.
in one of the ligatures, and one of them found on a tree stump
A root.
some distance away, or
Yes.
tree root. Yeah. And the argument from the state's point of view and from those that believe that the three are actually guilty was that this was transfer DNA. You could have picked up those hairs at
Yes.
home.
Mm-hmm.
My understanding of how the defense's argument goes, or should go, goes like this. If you are tying that knot and then you submerge that knot in water, any residual DNA on the ligature might get washed away, but the DNA inside that knot is going to necessarily be epithelial skin cells
Mm-hmm.
of the person who was doing the tying, of who handled that shoestring right before it was submerged in the water. That's not necessarily the case for the hairs, which hair can stick to clothes, hair can stick to things and not get
Right.
washed away. And it could very well be transfer, because the boys lived with the person that hair belonged to. However, it's harder to explain away in this situation where it's skin cells that might have been found in the knot itself, especially if it's in all six.
So, yeah. So those hairs were explained away. And I totally agree with you. Yes, we're looking for skin cells in these ligatures. If the DNA testing is done, that's what they're looking for, because that would indicate, handling the ligatures, tying the knots, that sort of thing makes sense. Let's imagine for a moment that one of the that well, let's imagine for a moment that the three who were convicted are innocent, as I believe, and that the killer or one of the killers of the boys is a relative,
Mhm.
and all three boys were in that person's house. And if you ask that person why his skin cells would be in those ligatures, if it was me, I'd say they were at my house every day. They're 8-year-old boys. Their shoes were always coming untied, and I helped all of them tie their shoes all the time. It doesn't matter that my DNA is on there. Why wouldn't it be on there? Then what?
So if that's the case, I would want to know, is this person's DNA the only DNA that was found? Because if what he's saying is right, my DNA should be expected to be found there because I've handled those shoelaces many, many times because I see
Mhm.
those children all the time.
Mhm.
Then I
And all
would
their
want to know,
mother's DNA should be there too, right?
and
Presumably?
any other and all the other parents.
Right.
And I'm not an expert on DNA. So maybe that's a question that we should ask the people doing the DNA analysis.
Mhm.
Is it, and in fairness, that is a recent criticism of what we call touch DNA, is
Mm.
that maybe some of these new technologies to pick up these minuscule amounts of DNA, maybe it's too sensitive. Maybe you're
Yes.
getting too much information, and that's almost as bad or as bad as getting not enough information.
Well, yeah, because
And
that does
so,
lead to wrongful convictions also.
absolutely. And so, if I think that if you're going to be testing the DNA against known samples, what I would want to know, and this is just me speaking as a layperson, I mean, I am an attorney and I've dealt with some of this stuff in my own cases, but I am not a DNA expert myself. But some questions that I would want answered would be, how many profiles do you think are here? How confident are you that you do see just one or just two or just three profiles? The
Mhm.
more profiles are mixed together, that actually makes it more, like, with each additional DNA profile you're adding to that mixture, it makes it harder and harder to separate them.
Sure. Mhm.
And so if it is the case that all of the parents, anyone who touched those shoestrings, even the boys themselves, if that is the case, then yeah, it might be that you find all of them there. I will tell you this, there is no reason for the three convicted there is no reason for their DNA to be there.
Exactly.
Absolutely none at all.
Right.
And if they are the killers, then it should be there. It should
Yes.
100% be there because
Absolutely.
we know that the killers handled the ligatures.
Unless they were
And
wearing
so
gloves.
And so I think that there's a possibility that you can get a DNA result that seemingly points to somebody, but on closer examination can be explained away and isn't enough to actually convict a third party or a parent or somebody that whose DNA may have an innocent explanation for being there. But what it really can do is it can provide, in my view, that clear and convincing, beyond a reasonable doubt proof that these three are actually innocent, because there's no way that it would retain DNA from one person but not the last person that touched it. And if Echols and Miskelly and Baldwin are the last person who touched it and someone else's DNA is on there and not theirs, that's impossible.
Right. So it's actually it's an interesting conundrum, really, because from the FBI study on M-VAC testing, it says that the M-VAC method yields more DNA than the swabbing method. It yields 12 times more DNA and 17 times more mtDNA. And then M-VAC, after swabbing has already been done, yielded 10 times more DNA and 9 times more mtDNA than just swabbing. So it's interesting because if they used a traditional swabbing, right, they might get 3 profiles out of a ligature. If they use M-VAC, they could get 7. I'm just throwing numbers out there. So it might be more confusing and more work and be harder to identify and isolate individual profiles using M-VAC testing than using swabbing.
Yeah,
It's just kind of
that
interesting.
that can be a problem. But remember, what the defense is doing is they're trying to exonerate their client.
Yes.
It would be wonderful if they could point to who the real killer is, because that would exonerate their client. But
Well, and if
they
you're going
only
to
need to
test,
exonerate their client.
correct, but if you're going to test the ligatures, which are arguably the most important physical piece of evidence that exists in this case, that has to point to the killers. We know, you know, I mean, we don't have time to go through the case, but anyone who's followed this case, unless you believe that the three are guilty and this was a planned, ritualistic, satanic murder of 3 8-year-old boys, if that's what you believe, you can probably turn us off now. But if you don't believe that and you believe that this was not a planned murder, all indications are that it was not a planned murder of 3 boys, then whoever killed them, they might have tried to be a little bit careful. Obviously, they, you know, submerged the bodies. They tried to hide the bodies for a little while so they wouldn't be detected, that sort of thing. They weren't wearing gloves, right? Probably.
Right.
Like who
Probably
walks
not.
around with gloves? So the chances of that are slim to none. Or that you would think to, you know, wrap a t-shirt around your hand. Like, and that's also makes it extremely difficult to tie these knots, right? If your hands are bound up in something. No one in 93 was thinking my
Hey, in 20
epithelial
years.
cells
Yeah.
might get sucked out of this ligature in 30 years, so I better be careful.
No, they were panicking and they were thinking, oh shit, oh shit, oh shit, I have to hide a body. I have
Yes.
to hide 3 bodies.
Yes. So whoever killed these 3 boys, their DNA is going to be on those ligatures. Now,
I agree.
I
Whether or not
believe,
it's drowned out by other data is another question.
well, and that's the thing, we don't know, but you don't know till you test. And
Right.
I believe that there's more than one killer, and I can't conclusively say that every person involved in the murders touched every lace. So I
Right.
think that there are laces that would yield more evidence than others. So I don't think you could pick a lace to test and go, this is the one. This is the one that's going to show, you know. But yes, you're right. There's no reason for the defendant's DNA to be on there. They absolutely, they weren't there. It does, their DNA hasn't shown up anywhere and it's not going to show up anywhere. So but I think if they're going to do the testing to help exonerate their clients, then that same DNA testing is going to absolutely point to a killer or killers if they can get conclusive DNA results from that testing. There's no way around it.
From the defense's perspective, I think it's important to make a distinction between epithelial cells that are in the knots, which 100%, like you said, had to be put there by the killer,
Yep.
Had to, versus a stray hair, which maybe was put there by the killer. That's why when the people that the DNA pointed to, when they did the original DNA testing,
we can say it's out there. It was Terry Hobbs and David Jacoby.
When Hobbs and Jacoby, they absolutely have an interest in an innocent explanation for their hairs being there.
Yes.
Of course they do. But the state also has an interest in an innocent explanation for their hairs being there, because if there's an innocent explanation, then that means that it makes perfect sense for someone else's DNA to be present and for the three to still be the killers. You really can't say that about DNA found in the knots.
Agreed. Yeah, I mean, they, if those hairs had been reversed, so the hair found in the knot was similar. Terry Hobbs could not be excluded as the owner of that hair. The hair on the tree root did not exclude David Jacoby. If those hairs had been reversed, I think we'd be having a different conversation, because Terry Hobbs was a stepfather of one of the victims. David Jacoby was not. So if David Jacoby's hair had been found in the knot in one of the ligatures, we would be having a completely different conversation.
Maybe. Because the argument for both was transfer.
Correct.
So if David Jacoby's hair was transferred to the crime scene, then it could have also been transferred to the boy's person. Because, I mean, if it was in fact transferred there, it was transferred there by the boys, which means it had to have been on them at some point. So I can still see that same argument being made, even though it's slightly less plausible, I think, at that point. Like it's more of a stretch.
It's quite the stretch.
But it's more of a stretch. I think you're right there, but I can still see them making the same argument, because it either got transferred over there or it didn't.
I can see them making the argument. I don't see people buying it, swallowing the argument as easily as they did with the hairs found where they were. But anyway, it doesn't matter, because they weren't found in the opposite locations.
So. True. No, that's true. That is true.
So we're talking about it for no reason. Okay, so let's go back to in the state's response, they brought up that there were other reasons that the jury convicted Damien Echols, and those included that he knew facts about the murder that were not available to the public.
Did he?
No. No. He originally, I guess, claimed that the facts that he knew he saw or read in a newspaper, and then I guess on the stand said no, he didn't know them from a newspaper. I don't know. But the facts that were given, like all the facts given by Jesse, if he got them right, it was because the police told him what the facts were, and most of the facts that he named were completely wrong, like didn't exist in the crime. So I'm not sure what they're talking about. That fibers,
are they talking about Damien though, or are they talking about Jesse?
They're talking about they said the defendant, so they're talking about.
So they're talking about Damien. Yeah.
Yep. That fibers on the victims were microscopically similar to ones found in Damien's home. Well, we're just going to throw that out as junk science.
We're just pseudoscience, complete junk science, which is interesting, because you are quoting and relying on pseudoscience in a motion opposing DNA testing,
Right, which is
actual
not
science.
pseudoscience, correct? Yes.
Like actual science. Yes, you're relying on pseudoscience in order to oppose actual science being done.
Yes, there's
So
there's
the
several
irony there.
yes, there's several points at which I go, the state does not know what irony is, because
Mm-hmm.
there were several things that I was like, wait, what? You're supporting something that you just like defended, and like I don't. It's very confusing, some of some of their arguments. So the next one was that a co-defendant confessed. So we're talking about Jesse's confession that Damien
Sure.
was involved.
Sure.
Which if you believe the three are innocent, you believe that Jesse's confession was coerced. And then it can't there's no corroboration of his confession. Most of it, like I said, didn't match the crime. So I don't know how you call that a confession. The next one was that there were witnesses who said that Damien confessed. That's true. One of those witnesses has recanted his testimony. And then the others were girls who said they heard this from Damien at a softball game. Most of that was rumor, but both Damien and Jason later said that Damien was saying that he had something to do with the crime, but it was a joke. Like he was being the big scary boogeyman, be afraid of me, I did this thing, joking around about it because he was a fool back then. And he said a lot of things he shouldn't have said, and didn't do himself any favors. And so he did say those things, but not because they were true, and not in a serious manner. And then the next one was that they have witnesses who said Damien was near the crime scene at the time of the murders. There was testimony from 3 people in the same family who claimed they saw Damien and Domini walking on the service road, which was near the crime scene. They state that it was near the time of the murders, which I think is interesting because that sighting was allegedly around 9:30 in the evening of the 5th, which is the day the boys disappeared and were murdered. There has never been an actual time of death. When the medical examiner was pushed on the stand to give a time of death for the boys, he said it, and I may get this wrong, but it was the wee hours of the morning. It was like between 1 and 4 a.m. or something like that, something along those lines. So otherwise, we don't have a time of death. We know when they were last seen, which was around 6:30, and that's it. So how the state can say that Damien was seen at the time of the murders, I'm not quite sure how they get there. And then, the credibility of those witnesses has been called into question.
Absolutely.
So there's that one. And then the last one is that DNA that exists that doesn't belong to Damien doesn't prove that he didn't do it. So we've already talked about that. So
I disagree with that. I think that that's the strongest. I mean, the defense in their reply focuses on that as their reply, right? No, it's absolutely impossible that their DNA wouldn't be in there if they're the ones that did it. Therefore, this will answer the question. And I absolutely agree with that. But I do think I would have also liked to see them respond in a way that you did to some of the specific inculpatory evidence from the trial, supposedly.
Yes.
I mean, even if they didn't go into a whole lot of detail, because they did cite some case law saying that in a situation like this, the court can consider not just facts at trial, but facts that are established after trial. And so I think that would have been a good segue into here are some additional things that we can prove up at this hearing. For example, that microscopic comparison of fibers is no longer an accepted scientific test, or the fact that we have some people that have recanted their testimony, or the fact that we now know that certain things are widely considered to be unreliable.
Yeah.
Even if you for the most part want to believe Miss Kelly's confession, there have been many experts that have looked at this since then that have said that it's a false confession. There are many things here that you can point to and say there are a lot of reasons why we don't have to take this at face value, especially if it contradicts other evidence. So I think that it would have made the reply brief better to add those things. I don't know. I'm sure there was a word limit or something like that, but I think that those things they should be prepared to address those things at the hearing, because the state's going to bring it up. The state is going to come in like they always do, and they're going to say the three are guilty. This isn't going to change that fact. There's no point in wasting resources on going back to an old case that has been solved for decades. That's what the state is going to say. And you have to be ready to come back with, we have a compelling case for innocence. There's a reason why this is a popular case. There's a reason why so many people know, and don't just rely on that. I think a big mistake in the first petition was relying on the notoriety of the case. Everybody knows these people are innocent, and
Right.
everybody knows that. Like, okay,
That's
but
illegal.
you need to show the court that, because if everybody knows that, it was so obvious, they wouldn't have their conviction still.
Right.
You need to show the court this.
Yes, I 100% agree. I have a question. Is there any scenario in which, now that all of this has been filed, that the judge doesn't allow a hearing and just dismisses it?
Maybe, but the defense is entitled to a hearing.
Okay.
So if that happens, if the judge just signs an order denying it, I would imagine the state can go back and say, no, we're requesting reconsideration and an opportunity. Yeah.
Okay.
Yes, that is what I meant.
Okay.
The defense could then go back and request reconsideration, ask for a record to be made. I don't see any reason why the judge would not allow that.
Me either. I just didn't know if that was an option. Like, I mean, I assume it's the judge. It's the judge's decision. It's his court. So,
yes, and and I'm sorry, I'm not super up to speed on Arkansas's procedural rules, but I mean, there are certainly comparable situations in where I practice, where I can think of a situation where you filed all of these briefs. Maybe it's been a considerable amount of time and you didn't ask for a hearing. And so the judge is just going to rule on it and is going to assign a denial. And then, you can go back and say, hey, I would like to make a record, because, you can appeal this if you lose. So you need to make a record.
Do you think there would be, so we have 6 ligatures. We're kind of done with the motions I just have other questions, unless there's something specific you want to address in the motion or the response from the state or the follow-up by the defense.
Thanks. I mean, just to say, I'm being very overly critical, and
No, go ahead.
I realize that, and I'm not trying to be nasty. Like, I'm not trying to judge anybody too harshly. I know that we all want the same thing, and I really do want Echols attorneys to succeed. I want to see the results of DNA testing just like anybody else. So I'm not trying to come up in here and say I would have done a better job or anything like that. These are just some things that I noticed. And I actually thought the reply brief was really good. I thought it was much better written.
Me too.
I mean, obviously you can pick apart any motion and come up with ways to make it better, and you can criticize anything. I just was a little concerned when I saw the initial petition, because I thought it left a lot of gaps, and I hope that they are able to turn that around at a hearing.
Yes, me too. So, kind of a procedural question. So the state introduced all these other reasons that Damien was convicted by a jury. The witnesses, all of those things that he confessed, that his one of his co-defendants confessed, all of that we just went over. Is that something that the defense needs to address in the hearing to say we can refute all of these things, or we can prove these things false now, or fiber evidence is junk science? Like, are those things that they need to address in order to say we can explain all of these things, we can refute all of these things that the state has brought up, so there's no reason not to do this DNA testing? It will show that they are actually innocent.
Would be best to. Do they need to? I think a very good argument could be made that you don't need to, that this type of testing, as we've discussed at length, it will exonerate them if their DNA is not there. And then it doesn't matter what all of that other evidence says, right? Because this is going to be, it's science. However, I do think it would be best practices too, because you want the judge to understand that this is not just because you do get DNA motions all the time from people, all the time, saying, do the DNA. It's going to say that I'm innocent. Absolutely. Let's do it. And then you do it, and then their DNA is all over the place. Right. And on the one hand, it's like, great, we've just gotten more evidence to keep you behind bars. But on the other hand, the flip side of that is that takes a lot of resources. And from the perspective of just a member of the community, right? I want our resources to go towards people that need them. I don't want every single person who's been convicted of a crime to be able to retest all of the DNA every so many years because the technology gets better and just because they can.
Mm-hmm.
Right? And that takes up a ton of resources and a ton of time,
Sure.
and it creates backlogs and prevents access for people that could really benefit from it. So from my policy, like doing what's best for the community kind of perspective, I do think that there is something to the judge wanting to see, why is it that I should even entertain this?
Mm-hmm.
Right? Like, yes, maybe you're right. If we do DNA testing, it could exonerate them. But as compelling as that is, why is it that you believe so strongly that you're right? Right? Why is it that you believe so strongly after they were convicted by a jury, and with all of this evidence, it seems, maybe I don't know anything about the case. Maybe, wow, that seems like a slam dunk. This seems really damning. Someone confessed,
Mm-hmm.
right? So why should I even entertain it? So I think it would be good to address it, even if you don't spend a lot of time on it. And often when you're doing a hearing, you can tell what the judge wants to hear and what the judge doesn't need to hear.
Gotcha.
The judge will generally let you know. Like if you're spending a lot of time on something that the judge doesn't really think is a big deal or think is relevant or doesn't care about, they'll let you know.
Yeah, move along.
Trust me. Yeah, I don't want to hear any more about this. I want to hear about this. I'm reminded of the yogurt shop murders, where they had done DNA testing in that case, and the attorneys on both sides had prepared for this hearing. They'd been working on this case for forever. The judge comes out and says, I don't care about anything but one thing. Tell me what this thing means. And judge did, I think, a really good job of really narrowing that issue down. And so maybe you'll get a judge like that who's just like, look, I've read these motions. I know about this case. Here are the answers that I want.
Yeah.
I don't know if that really answered your question. I kind of digressed a little bit there,
Okay.
but I think that, yes, it would be best. Come prepared to talk about the whole case. Show that you know more than the other side about this.
Mm-hmm.
A lot of these decisions are made because they're made based on credibility. Right? Like if I'm the judge and I don't know much about this case, and all I know is that I have two lawyers in front of me and they both are asking me to do or not do something, and I I'm on the fence about what to do, my instinct is usually going to be to trust the person that I feel I have the most credibility with, which is so often why prosecutors
Hmm.
seem like they're getting what they want just by telling the judge, "Hey, trust me, trust
Yep.
me, trust me."
They
And
have an
that's that
advantage.
always they always seem it always seems so shady, but it's human nature. If you're a prosecutor that works in that court all the time and you're only in that county and you only work with that judge and you work down the hall from him or her, you have that trust built up. I've
Mhm.
seen you in court a lot. I know I can trust you, or maybe I don't. Maybe I know I can't trust you. But if I know you, you already have this credibility. And so as a defense attorney that is from out of town, maybe I know that there's local counsel involved, but if you're not from there and you don't practice in front of that judge as often as the state does, and you're starting behind on that front, the way you establish your credibility is knowing the case better than anyone in the room, being able to answer those questions better than anyone else can, being able to talk about it, being able to demonstrate, I know this like the back of my hand. The state is wrong for these reasons. They don't know what they're talking about. Their witnesses don't know what they're talking about. Trust me because I know.
Well, and that's the thing. So, as many different appeals and motions and like all the stuff that's gone on in this case in the last 29 years, the state wavered. And I guess some people would say that's a good thing, but they're still relying on facts from 1993. And I'm putting facts in quotes here. They're they're, they're relying
On the trial
on
record.
fiber. Yes,
They can't.
and I get that. Like that's what they have, right? But so the defense has done, and there's been different defense teams. There's 3 defendants with different defense teams. Some of the defendants have had multiple teams over the years. There's been a lot of different work done, and there's still work being done today for the defendants. So what I mean, I totally agree with what you're saying, and so my response is the state doesn't know anything new, and the
Right.
defense should have a lot of new information.
They should, and they should use that
Yes.
because the state doesn't the state doesn't have the benefit that the defense has had of years of being able to gather new information,
Mhm.
and they don't know what that is necessarily. When you're pre-trial and you're trying to prep a case as a prosecutor, at least these days, you have to give all of that stuff to the defense so that they have an opportunity to look at it
Mhm.
and use it to prepare for trial. This could potentially be a huge advantage to the defense because there's no obligation to give the state anything that they have. They can show up for court for this hearing and they can put on evidence, and the state is going to have to right then and there on the fly
Respond.
defend
Yeah.
again, just respond to it.
Yeah.
And you really could have that benefit. I don't know what the defense has. I don't know what investigate, like I'm sure I mean, I know much more than me what everybody has and what's out there, but the state has made it abundantly clear that they don't know and they don't care. They're going to rely on the trial record because that's how they've been winning. Every time they've ever won, it's by relying on the trial record.
Right. And that's what
So
I'm
they're going to keep
saying.
doing it.
Right. So Cressman laid out all these points, all these reasons that beyond DNA, besides DNA, the defendant's DNA isn't there. But besides that, there's all these other reasons that we know Damien is guilty. And he lays them out point by point. And so if I'm the defense and I can go through all of those things and say, well, yeah, we don't use fiber evidence anymore. That's not a thing. And that's not
Right.
reliable. And I can prove that this witness was lying and this witness recanted. And this, like, you go through the list. And if you can answer to all of those points, where does that leave the state? Isn't that what you
Leaves
should
them
do?
with no case. Exactly. That's what you need to do is you need to gut their case.
Yeah.
I don't trust, unfortunately, most trial judges to know what your standard red flags are.
Mhm.
That's sad. But if you can show the judge, and even if you're putting on a show more for the appellate judge than anything, and you might be, right? If you don't think that the trial judge is going to grant your motion, then what you're doing is you're building a record to show the appellate judge. But anyway, cases, so like cases that I've helped on, you're trying to convince a high court, an appellate court, to grant your actual innocence claim. I know that's not what we're doing here. We're doing DNA testing. It's different. But really getting a judge's attention and really getting them to take a close look at a case, you have your recurring red flags, right?
Mhm.
False confessions happen under certain circumstances.
Absolutely.
Junk science that keeps coming up over and over again in exoneration cases, the same types of scientific evidence that appears in this. Witnesses that have recanted. These are not just, yes, you want to respond to the evidence and say, here's what we now know, and yes, I'm responding to these things, but not only am I responding to them, but these these pillars of the state's case that they're continuing to rely on, these are huge red flags. These are things that these are themes that show up in every wrongful conviction case we've ever seen, and they're being waved around by the state like they're reliable pieces of evidence when they're not.
Right.
More than anything, when you see them relying on junk science, that's a red flag.
For sure.
And I think that point needs to be made by the defense too.
Right. You want to rely on fiber evidence, but not DNA testing.
That in and of itself is a red flag.
Yeah.
Just the fact that the state put that in their brief.
Yeah. Well, I mean, they're regurgitating the same things they've said for the last 29 years.
Not even repudiate, like they don't even have the decency to take that part out. I mean, I
Right.
have seen plenty of cases where the state will say, okay, I concede that maybe we shouldn't have relied on this or that, or maybe in this area over here there were some problems, but overall, take those things out. We still believe in the conviction, and here is why. They don't even do that. They're, again, like you said, regurgitating the same things over and over without the decency of even taking out the things that are almost universally accepted these days as garbage.
Right. It's embarrassing.
It is a little bit. Yeah, it is a little bit.
There have been embarrassing things on both sides, let's be fair.
There has been, but I think what this shows you is, and maybe I'm wrong, but the sense I got from reading the state's response is laziness, but not laziness in terms of doing the brief. Like, it was a well-written brief. It was a well-researched brief. Someone did a good job on writing it. It wasn't that they didn't want to put in the work to prepare for the hearing. It's laziness in the sense of, we have our conviction. Here are the same set of facts that are over and over and over again. This is the talking points. I'm not going to look into it. I'm not going to even consider whether or not I might have a better argument by
Doing some
fixing
research.
that at all. No, I'm just going to keep using the same argument that's been working for me since the 1990s.
Yeah. But to your point, even if you didn't have the time or the energy or the will or whatever to look at a witness in the case that has been debated. Say you don't want to go down that rabbit hole. You don't want to figure out if that witness was telling the truth or lying, or if that witness recanted. You don't want to look that up. You just don't want to. You know, in 2022 that we don't use fiber evidence.
Yeah,
Like, that's not something you have to go
yes.
research.
This is incredibly common knowledge.
Yes.
I know you know this.
Yes.
I know you know this. You wouldn't have offered that evidence in a trial today, so take it
No.
out of your brief.
Yes. Like, why are we arguing this in 2022? I
Right.
don't
This is
care if it stood
yeah.
up in 1993. This is not 1993.
And to me, that is where the state loses a ton of credibility, because if you truly were doing this because you thought it was the right thing to do, then you wouldn't put that garbage in there. You wouldn't.
Right. Yeah. Well, the whole thing is interesting. I think it comes down to, like we've said, the DNA of the killers has to be present in all of the ligatures, all of them. So whether there's one killer, two killers, three killers, whatever you believe, that DNA. So everybody should want it tested, because if you think the three that were convicted are guilty, then their DNA is going to show up. And if you think that they're innocent, then you should want it tested, because the killer's DNA is going to show up. And
Yes.
so that is those ligatures are arguably the most important pieces of evidence to test. So unless you're going to tell me that it was a planned murder, whether you think it was a ritualistic satanic murder, or you think it was some truck driving serial killer who just happened upon the boys, but he has, his kit and he carries around gloves, the chances that the killer or killers wore gloves or somehow shielded their hands and that their cells are not in those laces is slim to none. I don't know what this unless the state is, unless the judge is just going to say there's no compelling argument to test this. There's no reason to believe that these three people could be innocent. And that all goes back to, for me, to the Alford plea, and we've discussed that before, but
I honestly think any reasonable judge with half competent counsel up there should grant this motion.
I agree.
If I was the judge, I might want an order that had a little bit more specificity to it. We talked about that kind of at the beginning of this conversation. Like, hey, I'm not going to sign an order that gives you carte blanche to go in there and test whatever you want. I need to know exactly what I'm ordering here, because we don't want fights later about what the order does and doesn't allow. I want a list, right? I want be specific. I can see the judge asking for that, and I think that would be wise if the judge wanted that. But I don't. Given the procedural nature of this case, there was an order vacating the trial, and then there was an offered plea. Those two things right there are red flags enough to grant a DNA motion.
Sure. What does it hurt?
Right.
I mean, if the state's not going to pay for it, the defense has agreed to pay for it. So it's not
so interesting to me. I forgot to mention this. I'm sorry, I did not mean to cut you off.
Very fine.
Where I live, if you win your DNA motion and you have a court order, the state has to pay for it.
Oh, interesting. I
So
didn't know how that worked, but yeah. So this podcaster, who's mentioned in the motion, agreed to have his listeners pay for the DNA testing. So I don't know how that works in Arkansas. If they win their argument, if then the state is responsible for paying for the DNA testing. But I do know for a fact that the defense has offered to pay for the DNA testing.
Yeah, I wonder why that wasn't more of a negotiation. Well, I guess maybe it was. I'm looking it up. I'm Googling it. Maybe Google has the answer. Maybe Google has the answer of who pays for it. Because I honestly think that's why so many DA's offices opposed the motions, is because of funding, right?
That, because I don't know the answer to that question, that may have been a carrot that was dangled in front of Scott Ellington when the defense was trying to get him to agree to allow to have the evidence tested without going through the court.
So I'm looking at the Arkansas Code 16-112-208 testing procedures. So it's Section A, subsection 3. The court may order the person who requested the DNA testing under this subchapter to pay for the cost of the testing if the court determines that the person has the ability to pay for the testing. So it looks like it's actually up to the court. The court may order the person who requested any DNA testing under this subchapter to pay if the court determines they have the ability to pay. So if you had maybe an indigent defendant, somebody that's still incarcerated who clearly doesn't have the ability to pay,
Hmm.
then it sounds like the county could then be responsible for the testing costs.
So if the defense is offering to pay, then that's just a hurdle, that they've taken away
Mhm.
from the state, that, you
Mhm.
can't, that's not a reason not to test. That's not something you have to come up with. That's not,
Mhm.
any kind of financial burden on the county.
Not necessarily, no, yeah, because it says the court may order the person requesting the DNA testing to pay.
Yeah.
Mhm.
Well,
I just wondered if maybe that was a motive for, being opposed, if they had limited resources, or if for
hmm.
whatever reason they want to be able to tell their voters that they saved money. I don't know. I don't know.
Is there any kind of time frame with these things? Like, can the I mean, could we not have any hearing or hear arguments for like another year? Or is there like, I know that there were certain amount of times like the state had to respond within, what was it, 30 days, 60 days, whatever it was, to the original motion. And then the defense had a period of time to respond to the state. Is there any kind of a timeline? And I realize it might be different in different states, different jurisdictions, but is there typically a timeline for the judge to schedule a hearing?
I'm looking at the statute right now. Let me see.
I'm just curious if we're going to find out anytime soon how this goes.
Yeah, I'm gonna I'm gonna look at this statute and actually see. New scientific evidence, writ of habeas corpus,
Mm.
form of motion. Look, the statute literally tells you what goes in the motion. Hearing. Unless the petition and the files and records of the proceeding conclusively show that the petitioner is entitled to no relief, the court shall promptly set an early hearing on the petition and
Mm.
response, promptly determine the issues, make findings of fact and conclusions of law, and either deny the petition or enter an order granting the appropriate relief. Hearings on a petition filed pursuant to this subchapter shall be open and shall be held in the court in which the conviction was entered. The court may order the petitioner to be present at the hearing. If the petitioner is represented by an attorney, the attorney shall be present at the hearing. A verbatim record of any hearing shall be made and kept. Unless otherwise ordered by the court, the petitioner shall bear the burden of proving the facts alleged in the petition by a preponderance of the evidence.
Mm.
The court may receive evidence in the form of affidavit, deposition, or oral testimony. The court may summarily deny a second or successive petition for similar relief on behalf of the same petitioner, and may summarily deny a petition if the issues raised have been previously decided by the Court of Appeals or the Supreme Court in the same case. So, yes,
Hmm.
there is a one bite at the apple rule.
Yep.
So long as if there are no new issues, this is their only chance.
Wow.
It doesn't have a time limit. It just says promptly.
Right. So let's define prompt, shall we?
Right. I love the vague, but
Yes.
there's no like within 30 days they must set a hearing kind of
Okay.
rule. It just says promptly. That's what it
So
is.
the one bite at the apple though is that's interesting. Sorry, I'm thinking while I'm talking. Um
Yeah, that's what it says.
so yeah, so the petitioner gets one chance.
Mhm.
S-
Petitioner.
So
If
if
this is denied, Baldwin can file the exact same
that's
motion.
what I'm saying. So I
Yeah.
wonder if this was a strategy
Maybe it was. Yeah. Maybe.
to not have Jesse and Jason join just in case.
Yeah, maybe it was.
Hmm. I might be giving them credit. That's not
We
due.
might be.
But after you read that, I thought, that'd be an interesting strategy. Which, of course, either didn't occur to the state because they pointed it out, or it occurred to them and they wanted to ignore it and find some reason to bring up the fact that Jason and Jesse didn't join in the motion and find a reason to point that out.
Yeah, no, I think that they're just lawyering. They're trying to find ways to create this no-win situation. That's what they're doing. I mean,
Well, that's
that's
their
my
MO.
that's what I think they're doing.
Yeah.
The damned if you do, damned if you don't. Like, well,
Mm.
they were all joined on the petition. You you filed your petition. It sucks. Too bad. That was your one shot. Kind of force them to do that kind of thing. But then if only one of them does it, it's like, oh, this is I'm sorry. I need to step in and protect Jason Baldwin's rights because I'm been so good at that so far.
So I have one final question.
Sure.
So you have said that you believe if the DNA testing is done on the ligatures, whatever they test, and none of the defendant's DNA is found, you believe that that will exonerate them, correct?
Believe that, yes.
Okay. So if once those DNA, let's say that's what happens in our scenario. That's what happens. There's DNA testing done, none of the defendant's DNA is found. So then those results are entered into the record, I assume. So then the defense makes a motion, I don't know how that works, for like asking for exoneration.
Yeah, and I'm sure that the specific procedure varies from jurisdiction to jurisdiction. But yes, first you need to do the DNA testing, and then you need a finding of actual innocence.
So I would assume then the state, after the DNA test results came back, the state would be able to make some sort of argument as to why those results do not indicate that that the defendants are in fact innocent, correct?
Could also concede that they were wrong.
Okay, do you know anything about this case? Are we talking about the same case here? Yes,
But
that's a
yes, but yes,
possibility.
yes.
So then a judge would decide, right? Whether the
Right.
state has a compelling argument or if the DNA shows the truth.
Right. And something I'm interested in is what then happens to the offered plea where they agreed not to sue for damages.
Well,
It goes
that's
away, right? It goes away, right?
does
Because if
it?
you're, I mean, if you get an actual innocence finding, your conviction is vacated.
Correct.
The offered plea is,
Gone.
obviously, yeah, if you pled guilty to something and then the conviction is vacated, the plea is withdrawn.
Right, which is, another reason the state will fight tooth and nail. Um, I mean, that was the whole thing that was talked about when there was this possibility of evidence missing, because that was the state agreed to maintain this evidence in the offered plea. So if
It
they
just seems like
lost,
they didn't have to make that agreement if they had a statutory duty to do so.
right, but so if they had lost it or it had gotten destroyed while in their possession or whatever, then, the argument would be that that violated their end of the agreement in the offered plea and that could be
Withdraw your
overturned.
plea.
Yep.
Yeah. Yeah, you can withdraw your plea.
So, yeah, so it's interesting, and so obviously the evidence was miraculously located.
Mhm.
Yeah, so it's interesting to see how this will go. I'm not as convinced as you are that if the DNA does not include any of the defendants, that's automatic exoneration.
Well, and when I say that, I guess I should clarify that in my mind,
Mine too.
it's like and with the caveat, I already believe that they're
Me
innocent.
too.
I personally would find hard to believe anything explaining away how they managed to commit this crime and do what they did without leaving their DNA in the ligatures. I would find that very hard to believe. But you're right. I don't know what a court's going to do. I can't. I've seen worse things happen, and unfortunately, and so
Well,
I shouldn't. Yeah.
it's all
Yeah.
confusing to me because in large part because there was DNA testing done, because the results of that DNA testing showed none of the defendant's DNA, and that is what allegedly led to the Alford plea. It doesn't make any sense to me because if your DNA isn't at the crime scene, then how was it that you managed to avoid leaving your DNA at the crime scene? And
No,
and
I agree.
and so but that didn't work for them. Like they didn't let it. I still don't understand.
No,
I don't
we don't
blame.
know if it was going to work for
No,
them
we
because
don't.
of the offered plea.
Because that's the whole thing. Like I've never been in their shoes, so I cannot judge. I wish all the time that they had waited. I mean, it was in the hands of a judge who was reevaluating their case to decide if they got new trials. I
Mhm.
I wish we could have seen that play out, but that's not what happened. And so
No, it's not.
you can't change that at all because that would have been really interesting. Um, I can imagine that the desire to leave prison is pretty freaking strong.
Well, the desire to leave death row is probably even
Well,
stronger.
for sure. So yeah, I don't blame them at all for taking that plea. Like I said, I haven't walked in their shoes. But I just knowing that their DNA has never been found on anything tested ever,
That's
I
compelling.
I just it's absolutely compelling, and at the same time, I don't know that it's gonna make the difference without taking away every other argument the state made in the case.
I see where you're coming from. I agree.
I
I can't say that I completely disagree with that. Yeah. And I think that what that means then is the first hurdle has to be get the court to order the DNA testing. And then, no, you're right. It's not a matter of, well, test results came back, case closed, conviction overturned. I think part of whenever I say, I think that I'm absolutely like they absolutely should be exonerated if that comes back is because I know so much about the case,
right.
right? If you get DNA results that exclude all three in the ligatures, that combined with everything that we know about the case, I think is what does it. You still have to put on that case, though. You still have to show here is why the pillars of the state's case at trial don't hold up anymore.
And that's what I'm getting at is I think in this case that is going to be necessary. And I think,
Yes.
in a lot of cases where there's DNA, not only can it exclude someone, but it's inculpatory. And so a lot of
Yes.
times they'll say, yes, it excludes John, but look at that, it's Pete's DNA. Now we know who the killer was, or
Right.
we know who the rapist was, or whatever. We haven't seen that yet in this case. But
Well, it complicates it because the main suspect, other than the three, is a family member who did share a house with them. I think it would be entirely different if it was a serial killer or if it was
of
somebody
course,
that is unrelated, because in that situation, there is no way to explain away the DNA that's found at the crime scene. And so it really
absolutely.
is a lot more cut and dry. But because the number one suspect in a lot of people's minds is a parent, that does make it a lot harder to definitively say, we have found the real killer. And so I think that in that sense, you're right. There are like, so, and I keep going back to Michael Morton just because I know that case so well.
Hmm.
When by the time they finally did do that DNA testing and they were able to show pretty definitively who the actual killer was,
Hmm.
that's what let Michael Morton out. And so often that is what happens. And unfortunately, I think that you're right in that you're not going to get that answer just from the science. You're going to get something that will help
Correct. Yeah.
point us in the right direction. You will get something that's much harder to explain, maybe, but you're not going to get a case closed, we have our killer from this DNA evidence. And I think that part of that will make it harder for the defense. But I do think that they still have a very strong case of how did our DNA get washed away by the water, but somebody who touched it earlier in the day to help them tie their shoes is still there. Please explain that to me.
Yes. Well, I think, it's a very unique case in a lot of ways, but the defense's job is not to catch the killer or killers.
Correct.
Their
Correct.
job is to defend their clients, to try to get exoneration for their clients. However, I think that in this case in particular, that the best way of helping their clients is going to be to take away all of the big, at least the big pieces of evidence that the state had against them in the original trials, and to point to who the real killer or killers are. I think in this case that's going to be something that is important to say, okay, for all of these reasons together, the preponderance of the evidence shows that, or the lack of evidence shows that my clients are innocent. And because all of this shows that my clients aren't innocent, are innocent, what we have left is what points to the killer or killers, and this is who that is.
Yeah.
And so I think I think it's an interesting, in some cases the DNA just points that person out. It's irrefutable. Let's say it's a rape case. You have the DNA of the rapist. There's one profile. Okay, well, if you can match that, we know who it is.
Right. Yeah, I think that
It's not that simple in this case.
it's often not that simple. There have been plenty of cases. You don't often hear about them because, believe it or not, most criminal cases don't get that much media attention.
Right.
But because of the reasons I said, we talked about earlier with touch DNA, the more sensitive something becomes, sometimes that cures problems, sometimes that causes more problems. Just because there's DNA in a case doesn't mean that you've solved it.
Right.
So, and I think that people are realizing that with this case, because there are a lot of reasons why, doing the DNA testing could just make it more complicated. But even still, I truly don't see how, if they're guilty, their DNA has to be there. Has to be. And I can't come, like, for me, that's what I keep coming back to. And but unfortunately, go ahead.
No, I was just gonna say, there's no scenario in which a 16, 17, and 18-year-old commit a triple homicide and leave no DNA.
Yeah, you're right.
That doesn't happen.
Unfortunately, the way the law is written, the defense has a burden to prove a really particular thing, and it's that the advances in technology, which they're going to be able to prove, I think, with no problem, but they also have to show why it may tend to show their actual innocence. And even though I feel strongly about that, it's almost like you pointing to the state and saying, you could have proven definitively that my client did it. You could do that now. You don't want to do that now, which is absolutely the case. Like, this is absolutely the truth, that the state could just agree to the testing and then throw it in the defense's face if it comes back with what it should, if they're guilty. But the state right now, the state no longer has any burden. And so they don't have to, and they're not going to. And so now you've put the burden, because that's what the law does, puts the burden on the defense to prove that they didn't do something. And that's always going to be harder. And it's so sad, because the situation is, you could end this debate. You could shut all of this down by just agreeing to the testing. But because that the law doesn't put the burden of proof on you anymore, you just sit back and be obstinate and not agree to anything and make the defense try to prove a negative. And it's the law completely allows it, but it sucks.
Yeah. Yeah. And I mean, I hope the testing is done. I absolutely want it. My fear is because of the history of this case that it might not make the difference that everyone hopes that it will make. And in addition to that, if the results came back the way I think that they would, based on what I know about the case and what I believe to be true about the case, it could potentially not only not exonerate by itself, not exonerate the 3 convicted, but it could, the DNA that does show up could point to the killer or killers and nothing be done about it.
Yeah.
And so that's why I think, let's say it's a perfect world, and starting now, of course, not previously.
Mhm.
Starting right now. And the DNA testing is done, and it points, it exonerates the 3 that were convicted and points to the person or persons who committed this crime. I still wouldn't want all my eggs in the same basket.
Oh, I 100% agree. And strategy wise, it doesn't matter how strong one piece of evidence or one argument is, you've got to throw everything you've got at
Yes.
this.
And that's the thing. That's our team has been working on, is all of the other things.
Right.
All of the other things that aren't being debated in the headlines right now.
You know, if even if legally you've met your burden to get that actual innocence finding, to get exonerated, that's wonderful. But there's still so many gaps in this
Mm,
story, and
mhm.
so many people are so invested in this that beyond just meeting a legal burden and getting relief for the 3 convicted, or even making an arrest down the line, there is so many answers that I think everyone involved in this case, and even to a certain extent, the public generally,
Mm,
really need to get closure on any of this, because it doesn't matter what a court says. It doesn't matter what a judge says. There's always going to be this side versus that
of
side.
course.
And they're always going to be going at each other. It's always going to feel unresolved no matter what a judge says.
Mm,
And so, putting all of the legal stuff aside, what you guys have been working on is working towards that
mm.
hopefully finally getting a resolution where we can put this thing to rest.
Yep. Yeah, whether it can be achieved in court legally, I don't know, but I think this case is absolutely going to be solved, and details that have been unknown will be known, and it will make a lot more sense, um, to anybody that's interested in the case. Whether it ever sees justice in a court of law, I don't know.
Yeah. Well, I look forward to that.